This is the plaintiff, Jordan Rosenfeld. He says he hired the defendant, an attorney, to help him resolve an issue with his co-op board. And the guy got tired of dealing with him and walked off the job. That's right, he plumb quit right in the middle of the case. The lousy lawyer now refuses to return the money he paid him. So he's here in the name of justice and is suing for the $5,000 he's owed. This is the defendant, John DeMaio. He says the plaintiff was being fined $27,000 for some illegal construction he performed in his apartment, and he was hired to help him out. He negotiated a settlement for $5,000, but the stubborn plaintiff refused to accept the deal. There was nothing more he could do to resolve the case. The two sides were at a standstill, and the difficult and angry plaintiff is owed nothing because he did what he was hired to do. He's accused of not seeing it all the way through.
Litigants have been affirmed, Your Honor.
Thank you, Douglas. Jordan Rosenfeld, you are suing John DeMaio for $5,000, the $2,000 retainer you paid him, plus another $3,000 for breaching the contract. Tell me what happened.
I'm a shareholder in a co-op, and I had been fined, and then there were legal fees on top of that for unauthorized construction, what they characterize as unauthorized construction.
You characterize it as?
Decoration.
Decoration, okay.
Tiling of my bathroom.
I'm not sure, but in any event, what was the fine originally?
Originally $500.
$500.
But then they kept
adding to it. And how did that fine become $500 and turn into what? 27,000?
Right. So it's not 27,000. It's about 20,000. It's a little under 20,000.
Which is equally crazy. And how did it become 20,000?
Because after it had been going on for a while and I'd been getting late fees to the tune of $50 a month, and no one on the board would agree to speak with me or to negotiate this.
Well, no one on the board would agree with you. That's the problem, right? Because what do you mean by no one would agree to speak with you? You just didn't want to pay the $500, and so you didn't pay it. Right.
I wanted to at least argue that, again, the condition of the bathroom was bad because there had been a leak from upstairs, and that I should, that retiling my bathroom was certainly within my rights as a shareholder. It didn't affect any other shareholders.
I don't think they're saying you couldn't retile by that. I think they're saying what?
They characterized it as unauthorized construction when it was basically
because you're supposed to get permission first, and there's a fine according to the agreements that you have with them as a shareholder. But in any event, I am not presiding over that case. I'm presiding over this one, which is that once it becomes $20,000, you hire a lawyer?
Yes. I mean, I didn't see any other...
And that happened when, 2007?
The actual tiling was in 2007, yes.
Okay, so you hire a lawyer what year?
In 2013.
All right. And the lawyer you hire is this gentleman? Or did you have any other lawyers before him?
I did have lawyers before him.
How many lawyers did you have before him?
I believe 2.
Oh, my goodness. Okay, so he's the third lawyer you hire.
Correct.
All right. And you hire him. How do you hear about him?
A friend of mine actually had told me that that Mr. DeMaio's current wife had worked for him in the past. And so that was how I heard about him. And then the two of us met, and he agreed that it was outrageous, and he agreed that something had to be done to sort of stop this from continuing to escalate, because they would just put late charges and legal charges on my bill.
And now it's $1 bajillion.
Right.
Okay. All right. So the other 2 lawyers that you had, were they working on an hourly basis or on a flat fee?
They worked on an hourly basis.
So you meet Mr. DeMaio, and he agrees to work on a flat fee basis?
Correct.
All right. And do you sign a retainer? Does he sign a retainer? May I see the retainer?
I don't have it with me, Your Honor.
You don't have it with you?
I mean, it's in the file buried. It wasn't part of my evidence. It's been subsumed by a Supreme Court decision that relieved me as counsel.
I'm sorry. Relieving you as counsel is one issue, and what you contracted with him, which is why he's suing you, is another issue. Well, I mean, he can't make you his slave. There's no indentured servitude. If you, if you have grounds to be relieved as counsel, a court will relieve you as counsel. I've done it a million times. Sure. But that is a different issue from whether or not you or he breached a contract that the two of you have. No, I believe. Are you suggesting to me that it's irrelevant what your retainer is? No, I'm saying that the judge, the only relationship we had was the retainer, and when I was relieved, that by force canceled the contract and put us in absolutely untrue, Counselor.
In
That's
a situation of quantum merit.
You have no. You have a contract with him, and you're telling me that it's completely irrelevant. The contract is completely irrelevant, so that's why you're not going to show it to me.
No, it's not that I won't show it to you, Judge. It's that it doesn't matter because the judge has already determined, and that's res judicata and collateral estoppel, has already determined that our relationship is over, and whatever rights he has left are implied contract and quantum merit.
I want you to show me a case that says that you can represent a guy for a couple weeks, you can get a judge to let you off, and you can keep the entire retainer regardless of whether... Let me see what that... I have a feeling that retainer's going to say to conclusion, doesn't it?
It does say to conclusion, Your Honor.
All right, show me the case. I'm always happy to be educated. Show me the case.
I don't have a case with me, Judge.
Oh, you don't have a case with you. You're just going to tell me about what a case says that makes the simple fact of a judge letting you out of a case mean that you are contractually, you no longer have to represent the guy, that's for sure. But whether you get to keep a fee is separate from that. Because if you have a retainer that says you will represent him for a flat fee of $2,000 plus expenses, against his co-op for pursuing all existing claims to conclusion, not including an appeal. And you didn't do that. How long did you represent him for?
I represented him for about 2 months, Judge.
Welcome back to the People's Court. Harvey Levin here. So can the lawyer keep the money up front if he negotiated a reasonable settlement and the client said, forget it?
Well, I feel like the lawyer should be able to keep it simply because that was something that they negotiated. And then once the lawsuit was won, they decided...
Well, it wasn't really won because the case went south because the client rejected it. Can the lawyer keep the money?
No.
Why?
I don't know.
It doesn't seem fair. Can the lawyer keep the money? Anybody think the lawyer should keep the money?
The lawyer should keep the money.
Because?
Because that's his upfront fee for doing all the work.
Fair point. Fair point. Going inside the courtroom.
In the 2 months, what was it that occurred?
Okay, what happened was I met with the client several times. I reviewed about 50 pages of documents. I prepared and filed the summons and complaint. I reviewed extensive answers and counterclaims. I have documents here that show that the co-op claimed he owed $18,000 plus $12,500 in attorney's fees, plus under the proprietary lease, he would be responsible if the case went on. They also canceled his co-op shares. I achieved an extraordinary result.
Well, you didn't achieve any result. You got an extraordinary, and I agree, extraordinary offer.
Well,
right. Because they said, let's settle for, and well, it's important, because a result is a result and an offer is an offer.
Yes.
So they offered to wipe the whole thing out for $5,000.
Yes, Judge.
And you felt that he should take it.
Well, I gave him an overwhelming recommendation. I advised him that the motion practice was coming, that it would be overwhelming, that he was exposed.
Yeah, I know. That's why he wanted a flat fee with you.
That's why he
doesn't want to pay you by the hour because it's going to be overwhelming. That's why he switched from the last lawyer.
Yeah. So, but what happened, Judge, is he wouldn't accept my recommendation. He failed to communicate with me, all of which constitutes...
Wait, how did he fail to communicate with you? I saw tons of emails you submitted into evidence where you're just like him. You're the same person. He doesn't like what he hears, so he says it's failure to communicate. You don't like what you hear, so it's failure to communicate. It's not failure to communicate. It's no.
Judge.
It's just what you don't want to hear.
No, that's
like
not
my
correct,
kids.
Judge.
Okay? You say to him, you should take the offer. He says, I don't want to take that offer. We're going to trial. And you say, oh, trial would be really a hassle. That's what you agreed to do. Take it to conclusion.
I sent a series of emails indicating urgent contact me regarding the offer. And
he continuously said, I don't want to take the offer. Listen, I'm with you. I think he should have taken the offer. But that doesn't matter because you and I don't get to decide what he does.
The difference in the settlement offer was $1,300, and he was exposing himself to the loss of his co-op shares.
It's crazy. It was like, I'm willing to pay $3,902, but I'm not willing to pay $5 because you just got to get some off. You just got to, you hate this board and they're nasty and they put you through hell, so you can't take their offer. It's crazy. But see, I don't care. Just listen to me. I don't care if their offer was $2 and he wouldn't pay it. The thing is, that's who he is. That's who walked into your office.
Sure.
That's who spoke to you.
Yes, Judge.
You know how this stuff goes.
Sometimes they get angry.
Oh, they get angry.
But
they
Judge,
act like it's like a divorce.
I'd
rather do a divorce than a co-op condo.
Every contract imposes an obligation of fair dealing and good faith, and he didn't do that with me. He didn't show good faith or fair dealing. He just showed obstinacy. I think that constitutes a breach and lets me out.
All you did was get an offer from them, convey it to him, and he said no.
No, I did much more than that.
Did you do any motions practice?
The motion practice was not done, but I did summons and complaints. I did answers. I did counterclaims. There was various negotiations. Letters went back and forth.
So why didn't you just finish with him? Just because the guy didn't want the offer? Why wouldn't you just finish the case? I'll tell you why. Because the reason why you wouldn't finish the case, do you really think you need to interrupt and put your 2 cents in right now? Are you capable of just turning off. There are times when you should turn off. There are times when you don't need to fight with everybody about everything. You don't hear that it's going your way. All you can do is mess that up. All right. You file the complaint, you get the offer, and the only thing he did was say, I don't want that offer. So if all you get the offer and then you say, I can't work with you. Well, why? Because the guy exercised his right to not take the offer?
No, because he was proceeding in bad faith. He was not
What's proceeding in bad faith? What did he do?
He was not communicating with me on a regular basis.
I'm sorry. I have tons of emails where he's communicating with you.
Yeah, but not regarding the settlement. I kept trying to meet with him.
Okay, hand me all the emails where you were communicating with him regarding the settlement, please.
And I do believe that the decision by the court constitutes a finding of a breach of contract.
I know you believe that. Now I want some authority because I don't believe that. You are not my first rodeo. I've been doing this forever. I have never heard anybody argue what you're saying. You're saying to me, if a judge relieves me, if a judge relieves me, by the way, you weren't even there for that hearing, that all that stuff takes place without you. Lawyers walk in and say, irreconcilable differences, judge. And judges say, sold, and they sign, okay? If you get relieved from a case, that means that there's no other discussion about whether you have to return a fee. That's just not the case. If somebody pays you $100,000 to represent him on a trial, and you walk in and tell a judge, I have irreconcilable differences, which you can have up to 20 minutes, you can have irreconcilable differences. And a judge says, you get to keep $100,000. That's absurd. So if you're telling me that that's the law, you need to pony up some case law. And if you've walked in empty-handed, do not complain. All right? I see email after email in July telling you, I don't want to take that. I knew they wouldn't do that. Offer them $3,900. Why do you keep saying it's a good deal without them? No. You need to return the money the guy paid you.
The lack of
and
communication
no,
is that
and
he
I'm not
failed
going to
to
sit
meet
down
with
and
me.
figure out what you're worth an hour because he didn't hire a guy by the hour. He hired a guy to do a specific thing, represent me till this thing is done. And you decided when it was done. In fact, there are numerous retainers that you could have written. You could have written, I will represent you for $2,000 for the first 2 months of negotiations. After that, if it goes to motions practice, I will charge you X. If it goes to trial, I will charge you X. If it goes to appeal, I will charge you. You chose not to do that. That's on you, not me. But you don't get, 2.5 times that just cause. That's not how it works.
Well, it's not just cause because...
No, it is just cause. I'm done with both of you. It's $2,000. Back to you. Verdict for the plaintiff.
Well, here's the lawyer coming out of the courtroom, the defendant on the losing end of this decision. Your reaction?
Well, the judge is a very intelligent, honorable person, and my adversary is a decent guy, but I don't think the judge understands that the cancellation of the contract relieves me of all obligations, and that I am then responsible only in quantum merit for my hourly rate, which is $4.75. So he got a great bargain.
What if she did understand it and you lost anyway?
Well, that didn't happen.
Really?
She didn't understand the law and point.
So what it looked like to everybody else that you went in there and argued your case and lost.
Judges used to be lawyers, and they were wrong, too.
Okay. Head right around the corner.
All right, thank you.
All right, so step on in here. You want to keep the argument going or what now?
Well, I remember when I was talking to him a few times, he said something like, you paid for a Hyundai and you're expecting to get a Rolls Royce or something like that. So that kind of arrogance was what we saw today. And that is who he is. I'm glad at least I got the feedback. I think that was justice served, but there is still a case pending.
What is your status with that case with the court?
It's ongoing. The defendants filed a motion to dismiss, and I have to respond to that motion, but I haven't had the funds to pay for a lawyer since he had the money until now.
All right. Harvey.
A lot of times you just immediately go to court when you have a fee dispute. With lawyers, many state bar associations where they're licensed, they have fee dispute centers where you can actually go to the state bar and maybe they can negotiate and settle your dispute short of going to court. That will do it for this case. Litigants for the next case on the way into the courtroom right now.